Welcome to this first lecture on the substantive issues of Introduction to Law. Now we will deal with the question of what is law. Ideally, you should come to this lecture after first having read chapter 1 of the book. But if you don't have access to the book, please still do listen to the lecture as the lecture has been designed to be thought-provoking rather than nailing things down. And then if you've read the book, you will be able to think through with it. If you have not been able to read the book yet, still you're encouraged to try to think through it, guesstimate your answers, and come up with some positions that you can debate in class. So, what is law? You will be surprised to note that there is no definition of law. The book does not advance one. And that's not because the book does a bad job at this. On the contrary, that is a very honest way to begin. Do you find that surprising? Think about it. It should be surprising. Do you think it has to do with the fact that it's actually very difficult to come up with definitions of things? Give it a shot. Try to give a definition of chemistry, or try to give a definition of biology. You'll be surprised to know that it's actually very difficult thing to do. But still, that might not be the problem. The problem might be something else. I do not want to settle this for you. I have a very clear view on this, but I don't want to settle it. Think about it. Why will the book Intro to Law not give you a definition of law? Might it be because it's subjective? Well, that's something to think about. Sometimes it's not quite possible to give a definition of something, but nonetheless, it's possible to give some common characteristics of that thing. Or at least it's easier to do that, right? And the difference between a definition and characteristics is that definitions typically are exceptionless. So if you define something as X, Y, and Z, that means that the properties X, Y, and Z will have to be present in every instance of that thing, and they will have to be necessary and sufficient to be able to talk about this particular thing. That is quite a difficult thing to do, as I just said, but giving characteristics of this is actually much easier. You can give some general characteristics without telling anybody that these are necessary and sufficient, and without telling anybody that these are exceptionless. So right now what we will do is start to give some general characteristics of law. Most of them are in the book, and we can also discuss when these characteristics fail to hold, when these characteristics are not really applicable. The first one is that law is about rules. Well, that seems to be self-explanatory, but I asked you, what is a rule? Can you give me a general idea of what a rule is? Let's say not a definition, because we already said that's pretty difficult, but can you give me a general scheme of what a rule is? Now, is law only about rules? Are there stuff in law that's not rules? The book gives us one example. I challenge you to maybe think of another one, but that might be very difficult right now. It might come back a little bit later. I'll give you a hint. Is equality a rule? Because sure, equality is very important for the law, but is that a rule? Okay, think about that one. And then you should also ask yourself, are there other social phenomena or even non-social phenomena, just phenomena that involve rules which are not in any way law? So then that's a good way to start to think about the characteristic of rules in relation to law. Okay, so through these rules and maybe through other things, law regulates conduct. So that law is interested in our behavior and tries to shape and guide our behavior. First, let me ask, is that absolutely true? Are there scenarios where law is not interested in conduct? This one's a little bit more tricky. I would say out of the cuff, I would doubt that one. I think law better be interested only in conduct and not in anything else. But okay, first question, does law only regulate conduct? And the second question is, are there other things? Are there other institutions that regulate conduct and that they're not law? So that one's pretty easy to come up with some ideas. The book gives you actually one example. The book says morality. Actually, morality can be tricky because there's more than one idea of what morality is, but I will leave that one there for you, and I will ask you if there are other systems that regulate conduct besides law. So the next one is that law is something that is socially enforced. So society takes measures to make sure that these rules, regulations, and maybe something else that regulate our conduct and maybe other things are actually put into place, are actually put into practice. And of course, you can easily think of other things that are socially enforced and are not law. Now, here I want you to think about something else. I want you to think about whether this social enforcement when it comes to law is different quantitatively or qualitatively from other things that get socially enforced. Now, I will give you an idea so that it doesn't sound too mysterious. So, for example, the rules of etiquette are also socially enforced. I would suggest that you try to enter into a restaurant without shoes or without a shirt and see how successful that goes. So you will get a form of enforcement, and that enforcement will come fast and surely. But the enforcement in law is actually quite different from the enforcement in the rules of etiquette, because a law, I will use a big word here, so but I actually want you to break it down. Law is institutionalized in its enforcement, and law has tools for enforcing decisions and making sure that things get done that etiquette does not have. So I said if this guy comes into the restaurant without a shirt or without shoes, that's going to get enforced. But what if he resists? So at some point, etiquette will have less resources to get things done than law. And that's actually quite crucial. That will give you some insight into something that's very essential to law that is not present in your reading. One final characteristic of law, or very common characteristic, is that law is about rules that have been laid down. So positive law, law is positive law. Positive here does not mean yay, does not mean optimism, does not mean good. Positive simply comes from the Latin word positus, and then it just means what I said, something that's being posited, laid down, put on top of something. And that's one characteristic of law that's quite important. Typically, law revolves around lawgivers, authorities that have the power to create the rules and then put the rules on the subjects. If we go back to the first characteristic of law I gave you, I said that law is about rules, and that's all right. But then there are cases of activities that have rules, and these rules have not been laid down by any lawgiver. To give you an example, the rules of math have not been laid down by a lawgiver. There's not a council of mathematicians that tell you, okay, these are the rules for making an integral or for taking a derivative. The rules of mathematics are not created by an authority, they are discovered. By contrast, the rules of law are created by an authority and they are imposed by that authority on the subjects. And this is quite important for legal reasoning because one of the very most central questions of any legal analysis is what has the authority said, and are these activities within or without the systems of rules or the directives that the authority has enacted. Of course, the characteristics that we have been presenting to you are, as I said at the very beginning, just that, characteristics. They're not exceptionless. And the same is true for this one, although this one's a little bit more polemical. Because there's a significant amount of thinkers that say, no, law is exclusively rules that have been laid down. But then some people will say, no, wait a second. Law must have some additional content, some additional restrictions that like the rules of mathematics, are not imposed, but rather discovered. And that is well, it's a bit of a minority position, but it's a very strong minority position. There are very good arguments to say, for example, that some dimension of equality is not something that is optional for the law. An authority cannot say, okay, now we'll have a law without absolutely any idea of equality. That will actually be impossible if you think about it. It would be some sort of Alice in Wonderland scenario. You can have a tyrannical legal regime, you can have it, but you are not going to get away with having that tyrannical legal regime insofar as it's legal without some dimension of equality. Of course, in a tyrannical regime, let's say a regime with slavery or some sort of Nazi regime, will have a class of people excluded from equality, and that is in itself that's quite horrendous. But to get off the ground at least some sort of putative or defective or corrupted legal system, at least within some sort of privileged class, there will have to be some degree of equality. Let's say tyrants between themselves, when they make contracts, will have to have some sort of idea of equality going in there. So, okay, that's for giving you a bit of a counter example for this one, that the rules are laid down, because this one's actually quite complicated, and we'll only really get into this deeply at the very end of the course when you read on legal philosophy. Another thing that's nice to think about now at the very outset, at the very beginning of a course, is to reflect on the areas of law. So typically the discipline of law is divided into some parcels. It's parceled into some different areas. And this is quite interesting that across geography and across time, these classifications are very, very stable. So the law typically does break down into these parts, and that holds content in the UK, in Russia, and in South Africa. And also, let's say 300, 400, 500 years ago, maybe sometimes new areas of law pop up, but the core areas of law tend to be very stable. And then we have, for example, in the private law, and the private law means it's the law that regulates relations between private people. Private people here is a term of art, and a private people means you and me, so it means just, let's say, citizens, and it also means the so-called artificial persons. Artificial persons are, let's say, not really persons, but constructs, institutions that the law treats like persons, grants some sort of legal personhood for practical purposes, and these would include corporations, which comes top of mind people very easily, but also other associations like, let's say, clubs, your football club, or also potentially, let's say, NGOs. So these artificial persons will also be persons regulated by the private law. And what's characteristic of private law is that private law typically assumes a very broad form of equality between private persons. You are a person, I am a person, the corporation is a person, and they're all set under the same under the same rules, and these rules are typically designed in such a way that nobody has an advantage, a de jure advantage, an advantage in law over anybody else. Of course, there are de facto advantages, and that's very polemical, right? It's one, if you say, so it's Gustavo versus Amazon, de jure we have exactly the same rules, there's no privileges vis-a-vis in relation to me and Amazon. There's no privilege. We're in a horizontal relationship, but of course you would know that Amazon has far, far, far more economic power and cultural power than what I will ever have. So and that's an area of polemic. A lot of people will say, if you apply that sort of system to people that are so different, you will create inequality, and that's why. And let's put that under brackets, because that's why the public law exists. But of course, if it's a relationship between you and your landlord, I think the assumption of equality works pretty well. Now, with some caveats again, but let's not get into that. Okay, so then private law. I have contract law, and that's self-explanatory. You know what a contract is, you just know it from common sense. Property law, that is self-explanatory. You know what property law is, and that's also just part of common sense. Tort law tort is a very archaic word, even in let's say in English, and then you will not immediately know what it is. I want to leave it for later to give you a complete characterization of a tort, but let's just say a tort. But let's just say that a tort is when I harm your economic or personal interests, and then I have amassed by the law to compensate you. Now, in opposition to the private law, the public law is a form of law that is characterized by a relationship between you, a private person, and the state, who is a public person, who is, let's say, and that means it's special. The state is special. So the state is not treated by the law as, let's say, some other corporation, some other NGO. The state has a special privileges because it is the state. Now, of course, in the past, we might think of those as the privileges of kingship, but now we will have to think about those privileges as the fact that state represents the public interest. It's not an institution that is aiming to pursue for at least not ideally, it's not aiming to pursue for its own interest, but for the interest of society at large. Then within public law, we have criminal law, which is sort of, again, self-explanatory. We have constitutional law, which for most people it will be self-explanatory. What do you have in the Constitution? The basic organization of the state that keeps the states in bounds and also ensures that the state acts in a way that's respectful of the rights of citizens. And we have administrative law, which, again, like tort law, I will defer an explanation of this for later, and here I will be even a little bit more mysterious. I will just say that just like it's a bit of like a MasterCard definition, right? For crimes we have criminal law, for fundamental rights we have constitutional law, and for everything else there's administrative law. Administrative law is very much a catch-all part of law, so it's very, very wide, especially nowadays. And then, of course, we have international law. I will just mention international law in a very wide sense as law beyond the state, beyond the confines of the state, so that I'm able to put there not just classic international law, which is literally about relationship between countries, so the relationship between Brazil and Vietnam, but also other areas of law that are international in the sense of being beyond the state, but which have much more ramifications beyond interstate relationships. For example, human rights, which is more about a regime that protects individuals than something that's about states, and EU law, which is actually even a very complex multi-layer field of law, but it's beyond the state in the sense that the EU is not a state, and it's this law that the countries of the EU have created on top of them as almost a federal arrangement. So this is not comprehensive. I have not touched upon every single subject, but it will just give you an idea so that we can get started giving a feel of the substantive content of the course. So for this final slide, I will just sum up what we said. We said that there is no definition of law. There's, of course, people have their definitions, but there's not one that I can tell you as being orthodox and being 100% right. I will ask you to think why that may be. There's also general characteristics of law that we can define a little bit more surely, granted that these general characteristics are not exceptional, they are general, not absolute. These include the fact that law is made of rules, that law regulates conduct, that law is socially enforced, and that law is about rules that have been laid down by some authority. And finally, we gave a sort of very brief overview into the different areas of law. I tried to be a little bit cryptic with tort and administrative law. I think with administrative law I succeeded because I like for you to get into these fields little by little instead to be told in a top-down fashion what they mean, because something can be learned about just coming up with an idea of these fields, which are a little bit harder to grasp at the common sense level. But then that's all for now, and I thank you very much for your attention. I will keep you posted.